afternoon, Mr. Kahl.
Good afternoon.
If you're comfortable, why don't we hear your opening remarks?
All right, thank you, Justice Wiggins and members of the Commission. It is a privilege to appear before you this afternoon. I would be remiss if I didn't start by thanking all of you for your service in this important process. I appreciate the significant time and commitment that you have devoted to your work and that you're continuing to devote to your work today and tomorrow. I want to begin my remarks this afternoon with two examples of my work as an Iowa lawyer. First, I want to go back to January of 2005 when it was my honor to appear in this courtroom before a special session of the Iowa Supreme Court. That session had been convened to hear comments from the Iowa Bar about the then proposed model rules of professional conduct. Those rules apply to all Iowa lawyers, including those of us who practice in federal court. Back in 2005, it was my task to appear before our Supreme Court to offer the views of the United States Department of Justice concerning matters of professional ethics important to Iowa lawyers. Next, I want to fast forward to January of this year when I was before the 8th Circuit Court of Appeals down in St. Louis arguing two criminal appeals. In one of those appeals, the main issue had to do with the impact of Iowa law on a federal sentence. This is because in federal court, criminal sentences oftentimes are driven in large part by the nature of the defendant's previous criminal convictions. The precise issue that was presented in St. Louis had to do with application of Iowa's aiding and abetting law as applied to an Iowa controlled substance offense conviction. This in turn required a fairly nuanced understanding of the relevant Iowa statutes and the Iowa Supreme Court precedent on that point. I begin with these two examples because I want to emphasize a critical fact to you this afternoon. I am proud to be an Iowa lawyer. As you know from my application materials, I have been practicing in Iowa's federal court since 1997, with several years of experience in other federal courts and as a law clerk prior to that. And while I certainly grapple with issues of federal law, there is often significant overlap with the law of Iowa. For example, just last month, the Iowa Court of Appeals decided a case called State v. Clemens, and the Clemens case had to do with whether a 911 call was admissible evidence under the so-called present sense impression of the hearsay rule. And I was interested in the Clemens case because it was relying on a federal case called United States versus Dean, which had held much the same on the same issue under the analogous federal rule of evidence, and I had personally been involved in the Dean case at both the trial level and at the appellate level. Another example I can provide is a case called United States versus May, a case of first impression that I argued in the 8th Circuit back in 2008, and which I also had prosecuted at the trial court level. May had to do with a defendant who had violated the then new federal sex offender registration laws, which basically required the federal government in a prosecution to establish that the defendant had violated the relevant state registration requirement, that is to say, as required under Iowa law, and also traveled in interstate commerce. And indeed, just this morning I was working on a brief for one of our attorneys addressing the issue of the reach of Iowa's carrying weapons statute. So I do work with Iowa law on a routine and regular basis. I have talked to many of you individually about why my experiences in Iowa's federal courts make me well suited to serve on our Court of Appeals. Among other things, I have emphasized my long and deep experience as an appellate advocate, which I think is important because appellate work is different from trial work. Appellate work requires a practitioner to think about the record that exists, not the one the practitioner would have liked to have had. And it requires precision and close attention to detail. For example, the appellate practitioner must evaluate whether an issue was properly raised and preserved in the trial court and must pay close attention to the appropriate standard of review. That is to say, what level of deference, if any, should be given to the trial court's findings that are being reviewed. Now, by mentioning my strong appellate credentials, I do not wish to be implying that my experience in the trial courts is at all irrelevant. To the contrary, my experience as a line prosecutor and trial lawyer has been invaluable to my appellate work. I understand the realities of trial practice and how they affect the later appeal. Through my trial court work, I've had the opportunity to work directly with most of those affected by the criminal justice system, to include stakeholders such as witnesses, crime victims, and those who serve in law enforcement. I have become involved in complex white-collar investigations involving commercial transactions. I have handled matters involving asset forfeiture and restitution, and I have litigated all manner of questions of criminal practice and procedure that routinely arise in both our state and federal appellate courts. I want to make two final points about my professional experience. One is that the practice of law is a lifelong learning process. It has to be because the law continues to change with our society. The impact of technology would be an obvious example of that. I have continued to learn and to adapt as times change and as the law changes, and I enjoy this aspect of my work. It is the lifelong learning aspect of the law that I think will help me if I am selected to serve on the Iowa Court of Appeals as I learn and confront new issues of law and join with my colleagues addressing new issues that come up that we haven't even imagined here today. The second point I want to make is that I am used to a fast-paced environment, which I understand is par for the course for our Court of Appeals. I handle a high volume of cases. I'm used to doing that in a cooperative and collegial environment. That's been my experience both as a line prosecutor and as a supervisor, and in particular in the area of appellate practice. I believe that this demonstrated work ethic will serve me well as a member of our Court of Appeals. So I come before you today as an experienced Iowa lawyer and as an Iowan by choice. For me, Iowa has been an ideal place not only to build a professional life, but also to raise a family and to be involved in the community. It is my desire to continue in service to my community as a judge on the Iowa Court of Appeals, and I would welcome your questions.
Mr. Kahl, thank you very much, and we'll start the questioning with Mr. Gray.
I'm sorry, we're getting toward the end of the day, so I can't remember if I guess I get to go first, so I can ask this question that will be asked at some point, and that is, one of the things that we've heard in this room is that being a district court judge is a very important prerequisite, perhaps, to be on an Iowa Court of Appeals. What do you say to that?
I think I have a couple of responses to that. I think if you look at the current makeup of the Iowa appellate courts, both the Supreme Court and Court of Appeals, we have a mixture of people who have come. Some have come as with experience as district judges. Others have come directly from the practice of law or government service. And I think that mix of people has served the people of Iowa well. I think I bring, as an appellate advocate, a set of skills that are going to be different than somebody who's been strictly a trial advocate or a trial judge. I've been used to thinking about issues and thinking about cases and looking at cases in a certain way. I think the final thing I would say is I think this commission has an opportunity with 6 nominees going forward to give some diversity to the governor to make her selection.
Thank you.
Mr. Harbach?
I have no questions.
Ms. O'Brien?
No questions.
Ms. Roberts?
Yes, as a follow-up to Mr. Gray's question regarding district court service, and then, let's take the leap to say that the governor would select you to be on the Court of Appeals. What would you see? Have you thought about what might be the real challenges, areas that there would be either a steep learning curve or anything related to that? Have you thought about what those might be?
Sure, I've thought about what the similarities will be to my current practice and what the differences are. I will feel very comfortable addressing the criminal side. I think about half of the Court of Appeals dockets are either direct criminal appeals or post-conviction challenges to criminal cases that raise issues of criminal law and criminal procedure. Now, I understand that sometimes the standards of review that the Iowa courts apply are different than the standards of review that I'm used to in federal court. There's, for example, more use of ineffective assistance of counsel to explain a question that was not raised below, as opposed to the plain error standard that's used in federal court, but the Iowa courts have not adopted. That takes about half of the caseload. The other portion of the cases obviously include a mix of civil, but also a hefty amount of family law, domestic issues, termination of parental rights. There would be a steeper learning curve there. I think I am a quick study. I think fortunately the issues, the legal principles in those areas are fairly well established, and so it would be a matter of learning and understanding those principles and then applying the facts that are presented to me to the particular case.
Ms. Conover?
Questions?
Mr. Bloom?
Yeah, in my note I have here, you said you had been an appellate chief for 25 years reviewing all work. Could you remind me again, just sort of outline what was involved in that duty?
Well, I've been, not for a straight 25 years, I've been the appellate chief on and off at the U.S. Attorney's Office. I started doing that work as an appellate coordinator in 2000. Then at some point became the criminal division chief. Then I was doing both jobs. So I don't want to leave you under the impression that I was doing that for that particular position for 25 years. In terms of what the work involves, we do what we call vertical prosecution in the U.S. Attorney's Office, which is to say that you handle your case from the beginning stages of the complaint and indictment and arrest and charge all the way through trial, sentencing, and appeal. So everyone's, with some exceptions, is doing their own appeal brief writing. My role is to supervise that aspect of our practice to make sure that our briefs are meeting the high standards that we have and that the Court of Appeals expects from us, to make sure that we have a consistent litigating position, to make sure that we are taking the positions that are consistent with what the United States Department of Justice wants us to take. Those are the sorts of things that I become involved in, and I have my own briefing and my own appellate practice as well.
Okay, thank you.
Mr. Goodman?
Thank you, Your Honor. Mr. Kahl, you've had, I guess, over 10 years of your career, 65 appeals, and I imagine it's many more than that if you expand it out to your full career. Is that correct?
That would be accurate.
And one of the things I'm trying to get a handle on is I used to be a federal and state prosecutor, so I have a great appreciation for prosecutors and their role that they could serve on the Court of Appeals and making sure that decisions are made properly. Can you give me an example where you've been involved in either reviewing an appeal, deciding whether to take it up to the 8th Circuit, or arguing a case before the 8th Circuit and thinking, boy, if they don't get this right, this is going to happen? And I'm asking that for the lay people that are on the commission and for me as well, to better understand the important role that a prosecutor or a public defender could play, or private defender, on a Court of Appeals when it comes to criminal matters.
Well, in the rare cases where the government can seek an affirmative appeal, either on a sentencing issue or maybe a suppression issue that comes before trial, we have to think very long and hard about the impact that a decision is going to have, not only on that particular case, but what impact an adverse precedent might have for us on other cases. And so certainly there have been cases, and I can think of a couple in my head, where we have foregone taking an appeal or pushing an issue in further on the thought that, okay, we can live with an adverse decision by one district judge in one case. If we take that up to the 8th Circuit and lose, then we're going to have created all sorts of problems for our colleagues across the circuit.
Thank you.
Ms. Diekma?
No questions.
Ms. Sinclair?
I'm just curious as to why you moved from the East Coast to Des Moines, Iowa.
Just lucky.
That's not a reason.
The reason I was with the U.S. Department of Justice doing criminal tax work. I got hired through the Attorney General's Honors Program, which is how they hire new law graduates and people like myself coming in from clerkships. I got a job in the tax division doing criminal tax work across the country. It was a wonderful experience as a young attorney, but I was really looking to settle down, and I was looking to settle down in a smaller U.S. Attorney's office, and I just happened to be in the right place at the right time, and so that's why I say I'm very lucky.
Good answer.
Ms. Sinclair, you've been doing long enough, you don't let them get away without answering your questions. Mr. Bevel?
No questions.
Ms. Law?
No questions.
Mr. Diaz?
No question, nice to see you again.
Mr. Berger?
No questions.
Ms. Bowden?
No questions.
Ms. Pearson?
No question.
I have a question. You talked about some of your experience in state court, and using state law. Do you think it's a disadvantage of not ever appearing in a state court, other than some public hearing we had?
I think I'm trying to maybe make that be a feature rather than a bug that I would bring.
I don't know if it's a positive or negative, and I'm just trying to figure out what your take is on it.
I think the deep experience I've had in federal court and issues that have that overlap will help me bring a new perspective to the Iowa Court of Appeals. I mean, I can't sit here and say, yes, I've appeared in front of Iowa courts on many, many occasions. I haven't had that opportunity. I haven't had that experience. I think that's a fair question. This is why I am sort of suggesting or arguing a diversity of professional experience would be helpful to the governor when you ultimately make your decisions.
That's fair enough. Thank you very much. Any other questions? We have a few minutes. Nope, seeing none, we thank you for coming and we wish you the best of luck.
Thank you very much.
Thank you.
Thank you.